Hello, welcome to another episode of The Latest with Law Simplified. I am your podcast host, Farin Ali. I am so excited to be back on the screens with you all. Today, I am joined by a fantastic guest. I am so honoured to be sharing the screen with him. I cannot believe that we've managed to bring him on for an interview. He is the head of chambers at Goldsmiths Chambers, a deputy High Court judge for England and Wales, and a tribunal judge in the upper tier tribunal for immigration and asylum, a highly renowned Queen's Counsel in England and Wales with over 32 years of experience as a practicing barrister, a leading silk in immigration, crime, civil liberties, for instance, actions against the police, and Human Rights 2021, Pro Bono QC of the Year, Male Champion of the Year, Finalist 2021. The list is endless. I am so excited and honoured to present to you Mr. Anthony Metzer KC. I will call you Tony. Thank you so much for joining us today. It's absolutely an honour. You're our very first judge to be on our podcast, so it's a huge moment for Law Simplified.
Well, thank you. It's a delight to meet you and to be able to be part of this. I'm very excited.
Thank you. Now, we've actually gone through some of your achievements, and I have to say that they're so remarkable. I know that you were voted as the leading silk in immigration, crime and civil liberties and human rights in 2021. You were also the Pro Bono QC of the Year and Male Champion of the Year 2021. Many congratulations on all of that.
Thank you. And strictly, I was nominated for a couple of things for Male Champion as opposed to winning it, but it was nice to be nominated. But yeah, the Pro Bono, which I think I won for the second time this year, was very rewarding. So thank you.
You're most welcome. I think we can get started and perhaps have a bit of an icebreaker. What do you think, Tony?
Sounds a good plan to me, Farin.
Fabulous. Okay, so what does a typical day look like for Mr. Anthony Metzer KC?
I don't think I've got a typical day, which is one of these. I find it so exciting doing what I do, and I love it after all these many years that I still get out of bed and think this is going to be an interesting day ahead. So it really varies. I mean, if I'm in court, and obviously, and these days one never knows if it's in court in person or in court remotely, but increasingly it's back in court, which I much prefer. In person. So if it's a court day, it's making sure I get the right trains or whichever mode of transport to get to the court in good time to be prepared, because obviously there's normally quite a big day ahead. And these days I'm more cautious to ensure that I think experience has told me to allow extra time. I think I was a bit, as a junior, a bit more prepared to be more trusting, which sometimes meant I came a cropper. But in general terms, if it's a court day, then it will be focusing on the case. If it's not, and I'm not in court that day, and obviously since I became a QC, it normally it's less everyday-ish in terms of being in court, because normally you're moving from one case to the next with sometimes a gap to prepare. So if it's a preparation day, I will either work from home or increasingly back in chambers, which I much prefer in terms of a workspace, and make sure I'm sort of use the day to prepare the case or cases, because sometimes if there's not one particular case, if it's a civil case that needs an advice, I'll be working on the drafting of it. But increasingly, as you know, I also sit as a part-time judge. So sometimes if it's a day where I'm sitting, I will, again, increasingly back in person, back at the Royal Courts of Justice. If I'm sitting as a deputy, I will go to the allocated courtroom, looking at the files and preparing for my day's sitting. So it really is a very varied diet. And sometimes if there's not anything major in terms of the work stuff, I will sometimes be focusing more on chambers stuff as head of chambers. And so at least some of the days, sometimes I'm doing more the admin side, or chatting to the staff or chatting to other people, senior people in chambers, to discuss what latest issue needs to be hopefully resolved.
I think perhaps a question in our audience's mind at this stage would be, do you sleep, Tony? Because from what it appears, you do so much, don't you? You have so many competing responsibilities that you're having to manage. So do you sleep, and how much sleep do you get every night? I mean, I want to know that too.
I do, thank you. I try and get my work-life balance not too disastrously on the wrong side. I'm very lucky to have a lovely family and good friends, and many of my colleagues I regard as friends. So I try to manage that side of things. Obviously, there are times when case crises come upon, and it's a late nighter preparing for the case the following day, and that definitely still happens, although perhaps less so than I was as a junior. So the answer is I do sleep, sometimes late and sometimes not for that long. I guess there aren't that many advantages to getting older, but one of them, in my view, one of them is, I think, that you actually do need less sleep. So my average would probably be 6 to 7 hours, which is normally enough.
That's great. It's good to hear that, Tony, because I think that came to my mind straight away when you were talking me through everything that you're up to at this stage. I have to say that I resonate with you because I'm also a court advocate, so I do go into court quite a lot. Yeah. Although a lot of the time I'm trying to work out where court is. So I'm running around trying to work out my Google Maps.
Exactly. There's a lot of stress around the process of getting to court, and then when you get to court, finding the right case, finding the clerk, finding your opponent, not knowing necessarily about the judge, and kind of get some information about the judge or whoever. So you're quite right. There's a lot of information gathering and issues that need resolving before you're even actually doing the case. And meeting the client, of course, as well.
Oh, absolutely. I think that's very important, of course. So I think you've already touched on what your sort of day looks like. And I know you've touched on that it sort of is from, perhaps you're advocating one day, you're in court as a barrister, and another day you're sitting as a part-time judge. How is it that you manage all these competing responsibilities, Tony? Because I can imagine it sort of overlapping sometimes. Is there a way that you perhaps manage everything all at once?
You're quite right. Sometimes I guess I think my wife once found an article that described type of characters, and one type of personality, it may be, Farine, you're this too, with somebody who's challenge happy. So I think I definitely come within that category of person. So I do like new challenges, and the combining of being head of chambers and various judicial positions as well, part-time, as well as the barristering, does present challenges. But I think, to be honest, it's got easier, not less easy in the last few years, partly because quite often, but not always, but quite often when I'm doing cases, I have really excellent juniors. I say quite often, sometimes I do cases and there's no reflection on the juniors who tend to be excellent. But when you have a junior working with a case, and if they are good at what they're doing, and or the solicitor is very well prepared and helps you with the preparation of the case, that takes away considerable amounts of the pressure. And when I'm sitting, I tend to have a rule, which is that I will want to make sure that I've safeguarded and earmarked a number of days, or at least one, but probably a number of days, reading time, preparation time before sitting, and also try and safeguard a couple of days at least for judgment writing as well, because you're absolutely right that if you're crashing from sitting one day to a big case as barrister the next, that can be really daunting and difficult. And I learned something when I first started sitting as a part-time immigration judge, right back in from 2002, that the best time to work on judgments or determinations, as they were in those cases, is very soon after hearing, because you get that nuance of how the witnesses come across, and my memory is not best at the best of times. And so although you're taking notes, you do get a real flavour of the witnesses and how the evidence came across immediately afterwards. So I try to do judgments quite quickly after the hearing.
Well, I have to say, it's absolutely commendable, Tony. I salute you for everything that you're doing. It's absolutely commendable. So perhaps we can move on to your journey to the bar and your journey to becoming a judge. Why law, and why specifically a career at the bar?
Okay. Well, as I think you know, I didn't start off doing law at university. In fact, studied chemistry for a year at university. I was privileged to study at a college in Oxford, and I had no plans really to be a lawyer when I first started at university. my plans actually at that stage, I loved chemistry at school. I had a really great teacher, and I'm afraid I was rather a nerdy character who tended to take chemistry books to bed with me. Back in days, which maybe not may not be that appealing for many, but I loved it, particularly in organic chemistry. So I loved all that. I'm afraid at university I didn't have the same thrill doing it. Partly that was, although the teachers were fine, I didn't get the same energy from that, and also the other students studying chemistry, I didn't feel we had a particular click. So that sort of, I guess my love affair with chemistry sort of ended in my first year at university. So then I decided I quite like to do law. The inspirations were a combination. There was a TV program, and you're far too young to know this, but it has come back to some extent again, although I don't think it was half as successful this time. It was a TV series which happened on, I think, 3 lunchtimes, I think on a Wednesday, Thursday, Friday lunchtime, to 1:30 and 2. It was called Crown Court, and it had the most amazing music. I think the music was by Sibelius. I'm not going to embarrass myself or you by trying to sing it or trying to hum it, but it had a very powerful theme tune. I think it was a suite by Sibelius, and it had a very sort of strong theme to it. And the clever thing about that TV series was that there were actors acting the parts in relation to these Crown Court trials. The jury, and they always announce this, the jury were all members of the public. So it was treated as though it was a real Crown Court trial. And obviously you only got excerpts, half an hour and 3 days, in which you saw some of the cross-examination, some of the judges' questions, and some of the summing up. And then at the end of the 3 days, you got the verdict of the jury. And it was a brilliant, brilliant program. I loved it. I was completely hooked by it. So that was part of it. And my cousin, who I'm close to, was a year ahead of me, and he was studying law. He studied law at Cambridge, and was a year above me, and I sort of looked up to him generally. And he said he wanted to be a barrister. And so the combination of, although he in fact became a shipping barrister, it's a very different area of law. Although the combination of seeing, nobody in previous generations of my family had as far as I know, had studied law. I don't think so. So I was the first of my generation, but I wasn't quite the first because of my cousin. So it was partly him, and it was mainly the Crown Court program that told me that if I wasn't going to be doing chemistry, and my plans originally career-wise was to work I wanted to do food research into food to try and eliminate cancer from different types of food products, which I think is very worthwhile, and a lot of progress has been done on that in the last few decades. But once I let go of that idea, and I decided I wanted to do law, I think crime and human rights in particular were what really has really driven me ever since.
My God, I cannot express how extraordinary that sounds, Tony. You know, there's a saying where they say that your career finds you, and it appears that your career found you, didn't it?
Yeah, I think it was that way around. I think it was that way around. I have to say I've loved it ever since. I've had lots of mini pupils. You'll be welcome to join me one time. Mini pupils, people who spend a week with me going around the courts, and I still get a thrill from the excitement of showing them the court rooms, the court process, and and everything that stems from being a barrister.
So you first stepped in court in 1990, is that right?
I think it was about then. I think you're being generous to me. It might actually be 1988, but certainly, yeah, I think it was a couple of years before that. But yeah. I started off, I did pupillage in 2 chambers, 6 months at each. In those days, you did pupillages for 6 months, not for a full 12 months. And I did the first 6 months pupillage in a chambers, which was then called 1 Dr. Johnson's buildings, which is where I in fact got tenancy. And I did the second 6 month pupil at a different chambers. They were then 11 South Square. They're now 25 Bedford Row. And 1 Dr. Johnson's buildings, where I was offered tenancy. I was very lucky to be offered that halfway through my second 6, so it took away the stresses of what would happen afterwards. Out of interest, I don't know if you know, but I was a joint pupil with Keir Starmer. I don't know what's become of him, but oh
wow, I didn't know that actually, Tony.
and we stay good friends, which is very nice. So that was really healthy competition. I mean, Keir's on top of everything else, and I won't get into politics, is a superb lawyer.
Absolutely.
And I realised that my chances of being taken on when I was in direct competition with Keir were negligible, in my view. So I went elsewhere for a second six, and I enjoyed those chambers very much. It was primarily a crime chambers, which they still are, 25 bed. They're very good chambers as well.
Absolutely, yes. Yeah.
And what happened was I was interviewed at one Dr. Johnson's buildings, and thankfully and happily they decided to take two. So Keir was taken and I was too. So which was great. And the significance of one Dr. Johnson's buildings is twofold. First of all, most of us broke away from one Dr. Johnson's in 1990 to found Doughty Street Chambers. I think 23 of us were the founder members of Doughty Street. Only one was QC, Geoffrey Robertson, who was head of chambers, and the only QC. And that was a very exciting time to form those chambers. But what was also interesting is that my first senior clerk, he was the second clerk then, and the third clerk then, by a quirk of coincidence in terms of my present chambers, where I'm head of chambers at Goldsmiths, are the same clerks. So I've been reunited. John Francis is now the senior clerk, and Tim McBennett, who was also a clerk in those days, is the head fees clerk in chambers. So I've been reunited with my two of the first clerks I ever worked with.
Isn't it so lovely though to be on this journey and to see the same people and the same faces as you go along and as you progress?
Yes.
Absolutely. So are you able to share your first experience in court? I know it's a very long time ago, 1988 or 1990. Can you share your first experience in court and how that went?
Okay, I can remember both my first appearance in a magistrate's court, and I will tell you about my first trial in the Crown Court as well. So my first experience in the magistrate's court was an experience, I think it was at Southwestern Magistrates Court in Clapham, and I had the rather scary experience, as far as I was concerned, of a defendant not turning up. As a junior, I was only doing criminal defence, although since I've become a QC, I prosecute as well. But in those days, I just defended. And my client did not turn up. And this happened on the third and the fourth cases I did as well. So 3 of my first 4 cases, I had no defendant. I started taking it very personally that they were not turning out because of me. But so my memory is of a non-appearance where at the end a warrant was obtained, not back for bail. And I thought I'd failed somehow on different levels, both because my client wasn't there and second, because I got the worst possible result for him. So those were my first experience in the magistrate. Occasionally, clients did even start turning up, and I actually had to do some advocacy for them. So thankfully, things got a little bit better. And I had one friend. I didn't really know many solicitors. I had one friend who instructed me on loads of my early cases. I think I lost almost every case for him, but he kept instructing me, which was incredibly kind, and meant that when it came back to the clerks, I could say, like, I've got this solicitor who's giving me work. So thankfully, I was kept in work a fair amount, partly because the clerks were very understanding in changes in pupillage, and certainly when I was a junior tenant. But also having that friend that I'm still really grateful to. We ended up, in fact, co-writing a criminal procedure book some years later, which was nice. My first experience of a Crown Court was rather a very different experience, and one, unfortunately, I remember, or thankfully it turned out okay, but I remember so starkly. I had started appearing in the Crown Court and done some short hearings. Well, my first trial was an affray case. I think it was an affray, certainly a public order offence, in Nottingham Crown Court. The chambers where I started, one Dr. Johnson, had a particular connection with Nottingham because many Nottingham solicitors didn't, at that time at least, instruct counsel in Nottingham. They felt that they were too placatory to the prosecution and wanted a real fight. So London counsel were instructed. I went to do this case, and I had friends who were staying in Nottingham. I couldn't afford to really afford anywhere to stay. So friends very kindly offered for me to stay with them. So we had the first day at court. I was by far the most junior barrister on this affray case. There were 4 or 5 other much more senior counsel who I'm sure sort of wondered what I was doing there. And They were not exactly impolite, but I certainly wasn't part of their crowd, the local Nottingham Inn crowd. So I felt a little bit lonely, but I thought it was fine. I went back to see my friends in that evening and had a fair amount dinner and a couple of glasses of wine. I think only two, thankfully. And then I'll tell you why, because shockingly, that night, my wife and my baby son, who's now in fact a barrister himself, were involved in a car accident where someone hit my wife in the back, and thankfully, it was okay. It all turned out fine.
Yeah.
They were both fine. My son was in a wonderful car seat that we were really grateful to the people that supplied it, and they were both absolutely. In fact, my wife was unhurt. My son was unhurt. My wife did have some whiplash, but she was fine. But she was in the hospital. So I was required late at night I had to come back to London, even though I'd had a couple. I couldn't drive because I'd had something to drink. So I got my friends very kindly took me to the station. I got the last train back from Nottingham back to London. Thankfully, they were both fine. And the following morning, I got up really early and went back to do the trial. So I don't even remember the results of the trial, but I do remember the first night being rather traumatic. But thankfully, all ended up well.
It's good going that you remember the first trial and the first appearance, because it's been such a long time. But you never forget, do you? You don't forget your first experience in court.
No.
It's unforgettable.
If I'm being honest, I think I do remember the end of that case. That affair, I think the client was convicted. I just didn't want to confess that too quickly.
Oh no. But I suppose winning and losing, it is generally a part of the process, isn't it? Naturally, justice runs its course, and obviously if someone's innocent, they're innocent, and if they're guilty, they're guilty. So it's not reflective on your ability, Tony.
Well, I'm not sure I can hear that, but I'm grateful. But what I certainly would agree with you, Farin, is that particularly when I was doing crime, and even afterwards when I started doing claimant actions against the police, you're up against it. The cases in crime, the evidence is often strong, particularly the more serious cases, and in claims against the police, the ones that don't settle early, ones that are fought and contested, tend to be the ones that the police think they've got a pretty good run at, pretty good chance of winning. So thankfully, I've never assessed my win-lose ratio, because I don't think it will be that great. But I agree with you. To be honest, it's not really about the results, as long as you hopefully do your best.
Yes,
it's about doing that. It's about giving the client your best possible shot at their case. Definitely.
So you then went on to become a judge, didn't you, in 2002?
Yes, so I became a judge in immigration and asylum law, of which I knew nothing. And thankfully had some very good training. Otherwise, I really would have been totally clueless. In fact, I sat as a first-tier immigration judge from 2002 right through till 2019, so for 17 years. And until I got silk and became a QC, I think in 2013, I hadn't done any immigration law at all, except as a judge. And in fact, I did quite a lot of sitting, and I did it to really, really enjoy it. But I thankfully was well trained, and also thankfully I've had some really good advocates appearing in front of me, so that they have sort of nursed me through that for the purposes of my decisions. But interestingly, once Goldsmith Chambers in its present guise was set up, and it was a merger of two chambers, of which old Goldsmith merged with the chambers I was in at the time, which was Argent Chambers, and I became head of the joint unit. We subsequently have acquired two large groups of other barristers from different chambers which has been wonderfully successful. We've had some fantastic practitioners joining on both those groups. And so chambers which had never previously done any immigration suddenly and dramatically has become one of the top immigration chambers, thankfully, in the whole country. And some of the juniors have entrusted me with their work. So although I've done it as a judge, it's really only since we had those large groups influx of barristers coming to chambers that I've actually done it as a practitioner. And that I've loved adding immigration, only acting for the claimants, the appellants in immigration law. Chambers doesn't act as a matter of Chambers ethos for the Home Office. So we act for the claimants or appellants in those matters. I've loved adding that as an extra area of practice.
Fantastic. And then you went on to become a deputy High Court judge and a judge in the upper tier tribunal, again in immigration and asylum. What is it like being a judge and making important decisions that impact and shape the lives of many?
Well, Farin, you're absolutely right. I guess it is quite an important. The decisions I do make are quite important. That really only applies in relation to the deputy. I'll come back to that in a minute, because although I was promoted to the upper tribunal of the Immigration and Asylum Tribunal when I acquired becoming a deputy judge, they've been short of work historically for deputies. So although I was trained up, I've not actually sat yet as an upper tier tribunal judge, although I do also sit as a war pensions tribunal judge as well. So I've done some of that, but primarily it's really the more senior work is the work as a deputy high court judge. And you're right, these are very, very important decisions. I gave a judgment recently in relation to a complicated personal injury claim for a woman who suffered a car accident. It was really about the extent to which she had suffered neurological loss arising from that accident. There was a huge challenge on the defendant's side. 4 experts were instructed on both sides: neuropsychiatrists, neuropsychologists, neurologists, and it was a quantum-only trial. But the defendant insurers, it was not the driver himself, it was the insurers, were arguing what's called fundamental dishonesty. In other words, she was making up the claim and relied heavily upon her social media feed, which on her Facebook feed, which suggested, superficially at least, that she could manage things a lot better than she was actually doing so in terms of the evidence that she relied upon. And so there was a lot of law in there, a lot of fact, and a lot of expert evidence that needed to be determined. And it's very much a different skill being a judge to being a barrister. I mean, in France, for example, or in many countries in Europe, judges are trained, really magistrates or judges are trained from the outset to become judges only, and not to be partisan by being barristers or solicitors on one side. And you will have seen the same way as I have, that when you're arguing a case, you're arguing forcibly and vociferously in favor of your client to try and achieve the best result. But it's a very, very different skill, because the skill as a judge, and I'm still relatively inexperienced as a judge. I've only done it since 2019. I do it part-time, but is nothing to do with trying to advance one particular case more than another. It's about trying to do justice, and that is a huge responsibility. And this case, for example, had lots of challenges, and it was very, very important. My son, who I mentioned is a barrister himself, reminded me rightly that you've got to be very careful that you don't identify with either side on this case, that you evidence objectively, you assess it, which witnesses do you believe, which evidence do you prefer, and try and come to the right result. And it's a very different job, because essentially you're not trying to get one particular result. You're trying to get it right in terms of justice.
And I think what comes with it then, Tony, is a lot of public scrutiny and media scrutiny. I think the case that you referred to actually made it into Law Gazette, from what I remember from memory. I have been reading a lot about you, Tony.
As far as I know, there's been no appeals. The judgment is sound anyway. It certainly was a lot of work, so it was a very lengthy judgment. So I pity you if you tried reading the whole judgment. But anyway, but thank you. Yeah.
I have been reading your cases, I must admit. So how do you deal with that scrutiny?
You're absolutely right. It's a hard thing. I think you have to put it out of your head and try and do the best job for the case you're trying. I mean, I've seen the situation from a different perspective. So recently, as you're probably aware, I was in a case which went to the Supreme Court just as the COVID period began. I had been acting in a libel case for some Polish publishers who were being sued in libel, and the claimant in that case was a very not an easy man. He represented himself. And the judge, I think the High Court judge, who actually has a very good reputation, I think became very frustrated by the way he gave answers and the manner in which he dealt with the trial generally. And from my point of view, in the course of the trial, it was obviously helpful to have the judge sort of on side, because it was a judge-only decision. And so I wouldn't be thinking at that stage about necessarily about how far the judge went in terms of asking questions. when the case came to the Court of Appeal and the Supreme Court, although we'd won the case before the High Court judge, they were very critical of the judge, and a retrial was ordered. Thankfully, there was no criticism of me. In fact, the Court of Appeal said I actually, at one point, I had tried to rein in the judge, which is a difficult balance because obviously he was on our side. But that judge, who's very highly regarded, and thankfully he still sits, and I hope will progress further as a High Court judge, that was quite sobering because there was criticisms both in the press, but also importantly criticisms from more senior judiciary, the Court of Appeal, the Supreme Court, and that was I found that very sobering, that you are vulnerable to attack or criticism, justified or otherwise, and obviously that's for others to judge, both in the press and importantly by more senior judges. So yes, you are very much in the public domain.
Definitely, and I have to say that given that you're delivering this role and you're doing so, bearing in mind all of the scrutiny, it is so difficult. Again, very remarkable, Tony. So I just want to ask you, perhaps we could conclude this section and we could move on to a bit of law. If you could use one word to describe your career to date, what would that word be?
Well, from my point of view, exciting. But repeating what I said in a different context, I guess what I would like to think is my career has been challenging. Yeah.
Well, you've achieved so much in a short space of time, but again, many congratulations on everything that you've achieved.
You don't need to say that, but kind of you. Thank you.
So moving on to a bit of law then. Now, we know, Tony, that you've acted in some of the most influential cases, which were in fact shortlisted for some awards. Now, particularly, you deal with actions against the police, don't you? And you tend to deal with particularly claimant work. So you're always up against the police. What types of cases or actions are frequently brought against the police that you've been instructed in?
You're quite right. I act for claimants and claimants alone, rather like I do in immigration. I tend to be I only essentially work for one side. There's one exception to that, which is probably a case I'm going to mention briefly. But primarily, the cases I have brought have been ones in assault, false imprisonment, malicious prosecution, misfeasance in public office, sometimes data protection breaches, and human rights claims. So those are the primary areas of civil claim. Obviously, there are other areas of negligence and other torts as well, but the typical cases are what I've said.
And could you perhaps, if we look at false imprisonment, just as an example,
yes,
could you tell our audiences what is it that the court would consider in those types of cases?
Well, claims against the police, particularly ones involving false imprisonment or malicious prosecution, there are very few areas of civil law that you still have a right to a jury. It's basically gone away, unlike in the States, as I'm sure you know, where civil claims are tried by juries. Here, there's almost none. Cost saving has required that. I think there's still a possibility of it's smaller areas of defamation law, but other than that, it's really only in this area of law that you can have jury trials, which has been great, because rather like in crime, you can make your case to the jury irrespective of how the judge thinks about your case. And sometimes this area of law can attract a lot of views of the judges as well. Some judges many judges are absolutely fair and try the case properly and fully, but there are also judges who are quite partisan in this area of claims against the police, and I wouldn't want all the cases ideally to be tried by judge alone. So it's great to have juries. So on false imprisonment, you will want to be arguing that essentially, normally the issue of imprisonment was detention is not really in challenge. The real question is whether it was false imprisonment. In other words, whether the arrest was unlawful. And there are legal questions that may need to come before the judge, but ultimately for the jury, you're going to be arguing that the arrest was unlawful. And importantly, for that particular tort in false imprisonment, the burden is on the defendant, the police, to show on the balance of probabilities that the arrest was lawful. So you're looking at the legislation and the factual circumstances. Was the underlying arrest lawful?
Now, I can imagine that you've probably dealt with so many cases to date. is there perhaps a case that sort of stands out for you? Do you have a most interesting case that you dealt with, or an action against the police?
Okay, well, thank you. I was going to mention one. I'm going to mention three cases briefly, one of each of the three areas of law which I mainly practice in. The defamation case I mentioned, it's not normally my area of practice, though I love doing that case. Yeah. So one of each, and I'll try and do it shortly. The claim against the police, actually, that area is the only time, as far as I know, I ever acted for a defendant. Was in a case which was later reported as Hunt against AB, which went ultimately to the Court of Appeal, where I was acting for the defendant pro bono in a circumstance where a man who had allegedly, and in fact it was found by a court, had raped my client. He was working at the time as a magistrate, as a part-time magistrate in a coastal area. And he went to prison for that, but he got out, having served time in prison. He got out in the Court of Appeal on what I regard as a legal technicality, and then pursued my client for malicious prosecution because she had alleged that he had raped her. She was an absolutely lovely woman, and in a terrible state, because she could see, having made allegations against him, having done a Crown Court trial, having been believed in the Crown Court trial, he'd gone to prison for rape, for 4-year imprisonment sentence. So there were issues that needed to be resolved in terms of her own marriage, because her husband didn't know about the background. But more importantly, really, she risked the possibility of being found bankrupt were he to succeed in a malicious prosecution claim. So she went to a firm of city solicitors who on a pro bono case, and they do a lot of that work. And I was brought in as counsel, and we were able to successfully argue both before the High Court and the Court of Appeal that she was not the instigator of the prosecution, and so the case was thrown out, and she won again in the Court of Appeal, and avoided a trial, which would have been terribly traumatic for her. So that's probably the case on malicious prosecution that I remember the most. In crime, I'm not going to spend length talking about the time I had to cross-examine Nigella Lawson for many hours. So that's probably.
Oh, we must. We must.
I'll come back to that one, but that was a case I did just before I became a QC, and that was obviously a pretty extraordinary time in 2013. That case did get a lot of TV and media attention. On crime, though, the one I think the most recently I'm excited about is a case where I've been instructed with a small legal team as a junior from Chambers and a solicitor who instructs us in relation to private prosecutions of cases where religious Orthodox Jewish women are being denied what's called a get, which is a religious divorce certificate, which I instigated together with discussion with a particular solicitor, a different solicitor, that we would bring, using the criminal law of controlling and coercive behaviour, Section 76, the Serious Crime Act 2015, to instigate cases in which this was one manifestation of controlling behaviour by the man. The women, on the whole, would have a civil divorce, but the man would chain them essentially from remarrying or having children with anyone else by refusing to give them the divorce certificate. And very recently, we've done a number of these cases. Very recently, a defendant man, a very financially successful property man in his late 50s, similar age to me, was in fact, on his own plea, found guilty of controlling and coercive behaviour and went to prison for 18 months. So it was a very sobering thing for him, and very exciting in terms of hopefully liberating women in that situation. And much of my practice, I am very keen to try and assist both colleagues who are women and those from minoritized backgrounds, and it was nice to be able to do that in a professional context as well. So that was the criminal case most recently that I'm very proud about, although, as I say, Nigella probably was the most publicized. And finally, on immigration, I was excited to be brought in by a very good junior colleague in Chambers who practices as an immigration practitioner, and she brought me in to lead her in a case which we took to Luxembourg, and succeeded both in Luxembourg and ultimately back in the upper tribunal in the UK concerning the rights of a discrimination issue to do between married and unmarried couples, and an issue about extended family members, whether they were under the same definition as narrow family members for the purposes of equality before the legislation. And we won the case, and that was incredibly exciting to be doing that case there in the CJEU in Luxembourg. And as a result of that case, the case that we did, the law in England and Wales was changed 3 times to fit in with the decision in Luxembourg. So that was very exciting legally.
Well, all of that sounds very exciting to me, Tony. Are you able to talk about Nigella Lawson and when you cross-examined her?
Okay. Yes, I can. Okay.
I think our audiences will find that very interesting.
Okay. It was. I was acting for. I acted for both sisters in the civil case and in the criminal case for one of the sisters. They were called the Grillo sisters, and my client was the younger of 2 sisters, Elisabetta Grillo and her sister Francesca, were being prosecuted in relation to alleged fraudulent misuse of Nigella's ex-husband Charles Saatchi's business card in relation to excessive purchases on luxury items, holidays, and the like. And they were prosecuted at the most surprising place of Isleworth Crown Court, which is hardly Sloane Square. But Nigella and indeed Charles Saatchi were required to give evidence in that case. And I had to cross-examine her. And she arrived into court, and it was the closest moment I've had to seeing a film star. So as she walked into the court, formerly you couldn't have any cameras, but I'm sure there were cameras going. But also you saw all the journalists on their laptops are literally taking. It was like a dramatic moment. She walked in. She's obviously a highly intelligent woman, very beautiful, and she was dressed very soberly in a black suit. But it was, as I say, rather like a film star entry, and it was rather daunting from my point of view to then have to give her a hard time for many hours, which I'm afraid I had to and did. And you might recall this case where there were issues about whether she'd taken cocaine,
yes.
and the playback of her marriage, sadly her marriage that broke down between her and Saatchi. And that was the backdrop in which this trial took place. But happily, from my client's point of view, and indeed her sister, both the Grillo sisters were acquitted of the allegations. So it was an exciting case. And at the time, there was a journalist who sent me afterwards. He took I still have it at home. He did a sketch of based upon Charles Saatchi, as you probably know, had and I think still has a big art studio, and he commissioned the Damien Hirst shark in formaldehyde, which was one of his sort of most exciting pieces that he had. In the course of that case, the barrister sent me afterwards a sketch which had a barrister had a barrister inside a tank, and the heading underline was barrister in formaldehyde, which I think was supposedly me. So that was quite exciting. Yeah, we still ate the Nigella food during the course of the case. But one evening in the middle of the trial, somebody came up to me and in a social context and said to me, "What's it like to be the most hated man in the UK?" And I said, "I think I'm only the second most hated after Charles Saatchi. I don't think I attracted much sympathy in that case, but I definitely knew what he meant, because there were many people who were not very thrilled that I was giving one of the nation's treasures such a hard time. But obviously I had to. It's
part of the job, isn't it, Tony? Duty to the client. What can we do?" Did you get any cookery tips? Any cookery tips in the process, perhaps during the cross-examination?
I don't think she'd have been well disposed enough towards me to offer me anything, but we did carry on having a chocolate cake.
Oh, that's good. You also appeared in the Court of Appeal recently, didn't you? I think it was a case where the court was examining the human right to buy sex, and you were accompanied with Dr. Charlotte Proudman. Are you able to tell us briefly about that case, the judgment, and very briefly its significance, please?
Certainly, yes. So that's a case called RC. Charlotte, who's a friend and colleague in Chambers, brought me into leader on that case. We acted for, we intervened on behalf of two women's organisations. We were instructed by the really impressive CWJ, the Centre for Women's Justice, who instructed us. But we were essentially acting for two organisations. What had happened is that a High Court judge in the Court of Protection had been asked to consider a question as to whether or not a care worker for a disabled person could be potentially committing a criminal offence if there was circumstances in which a sex worker came in and did sexual services for the disabled person, whether the care workers were in somehow going to be held criminally liable for enabling that circumstance to arise, which struck us as a very concerning thing. And the judge in the Court of Protection had held that they would not be exposed to such a risk. The Court of Appeal, the prosecution appealed that decision. It was a preliminary decision. The prosecution appealed that, and we were brought in as interveners to support the prosecution because we were arguing this was very essentially our clients were arguing very strongly that this was going to this situation. First of all, I think there's this very strong argument that increasing argument that prostitution is actually making it much harder for women, and that they are more exploited. A lot of the women who are involved in prostitution or sex working tend to be trafficked. And they are often not they're not giving sexual services in a free way. But as I say, they're trafficked or otherwise under huge pressures. And that this judgment was going to be concerning because essentially, if the decision went the other way, it would be, take the term shortly, it would be a right to buying sex. In other words, people have a basic right, not a right to sex, but the right to buying sex. Yeah. And thankfully, the Court of Appeal, in my view, exceeded the prosecution case, and they very, very helpfully made reference in their judgments to the contribution that we made on behalf of our clients, these two women's organisations involved in prostitution or sex workers, and we were able to produce a lot of evidence to show the dangers and the risks there are to such women in such circumstances, and essentially, taking it shortly, the Court of Appeal said there was no right to buy sex.
I suppose the one thing that comes to mind then, Tony, is that people that are in care homes that do lack mental capacity to make decisions like these, such as buying sexual services on their own, if they are wanting to access sexual services, on the back of that ruling, they can't do so through a care worker or a care home.
That's right.
So I suppose the question is, what are they to do in the circumstances? Do you think that the law is unsettled at the moment in that respect?
I think it is unsettled. I mean, it can go into a much bigger debate as to direct access between the disabled person and access to sex. I think the narrow question was that it shouldn't be right for care workers to be put in a risk in relation. Their responsibility is far too great to be at risk in relation to a criminal offence. I do have views, and I think those are largely according with the position that we took in the case in relation to the dangers and the risks to women, particularly young women, who are exposed in this situation, and that it's not, in many cases, completely free for them to pick and choose as to whether or not to perform sexual services for money or for services. So I'm very troubled personally about the dangers and the risks, particularly as I have done quite a few cases of sex trafficking and the like. But I think the question as to whether disabled people or people generally should have the right to purchase sex, I think is a very, very loaded and difficult question. I can see the arguments very much the other way. I know that in some jurisdictions they are moving towards making prostitution, and I know in some jurisdictions prostitution is now a criminal offence, which is new. Of course, that is not an offence here in the UK, but there are offences not far away from it, such as using a brothel or soliciting and the like. But at the moment in the UK, there is no crime of using a prostitute, but I think that question, whether the law changes, I don't know, but that's very much a live question for the future. And I think the evidence is increasingly clear that that many of the women involved in that service industry are not giving sex, being paid for sex in a free way, and I think it needs to be very carefully scrutinised.
Absolutely. But thank you so much, Tony. That brings us to an end. Can I just say it's been an absolute pleasure to speak to you. And I want to thank you for your time this afternoon, because I can imagine that you have lots that you could be doing at this time. And instead, you've joined us. So thank you so much.
My pleasure, Fiona. It's been a real pleasure meeting you and discussing this all with you. And I hope very much we'll meet up again soon. And I wish you well. And I hope the podcast series continues to go as successfully as it already is doing.
There we have it, ladies and gentlemen, Mr. Anthony Metzer KC. What an absolute honour it's been to interview him. I still cannot get into a habit of calling him Tony. Anyhow, I have pasted the link to Tony's LinkedIn profile and his profile on the Goldsmiths Chambers website in the description box. Do check it out right now and make sure you follow him. If you require any representation in his areas of specialism, so immigration, crime, civil liberties, for instance, actions against the police and human rights, do reach out to his clerks. We're now heading over to TikTok, where Tony will answer 2 unseen fun questions. So do make sure you head on to Law Simplified's TikTok account, which is Law Simplified UK. Do follow us on all the social media platforms and subscribe to this channel, because we're going to be coming to you with some fantastic guests. Make sure you always keep in contact with the law. It's been an honour, folks. I'm signing out now. Bye-bye.